Hello everyone. In the last presentation, we have seen that in the beginning, when Articles 21 and 22 came up for interpretation before the Supreme Court in Gopalan versus State of Madras, the court held that Articles 14, 19, and 21 were mutually exclusive and independent of each other, and a law affecting life or personal liberty could not be declared unconstitutional just because it lacked natural justice or due procedure. In Maneka Gandhi's case, Article 21 got liberated from the restrictive meaning placed upon it in Gopalan's case. It came to acquire the power and strength which was not previously thought of. A number of creative decisions of the court that followed Maneka Gandhi's case gave a new meaning to the article and expanded its content and implication. It brought to life the right to life and personal liberty, which was lying dormant for nearly 3 decades. After this decision, the scope of protection of life and personal liberty under Article 21 was expanded and it became a source of many substantive rights to the people. In this presentation, an attempt is made to briefly deal with some of the cases where the scope of Article 21 has been expanded by liberal interpretation. First of all, let us see how right to life under Article 21 affected the infliction of death sentence under Section 302 Indian Penal Code. When the question of constitutional validity of death sentence was raised before the Supreme Court, first in Jagmohan versus State of UP and then in Bachchan Singh versus State of Punjab, the court held that the sentence as such was not violative of the provisions of the Constitution so long as the penalty is inflicted in the rarest of rare cases. For this, the circumstances under which the offence was committed and the circumstances under which the offender committed the offence have to be taken into consideration to decide whether death penalty is the appropriate punishment in a given case. In Sundar versus State, the Supreme Court held that only in those exceptional cases where the crime is so brutal, demonic, and dreadful so as to shock the collective conscience of the community would it be appropriate to award death sentence. In Dina versus Union of India, the apex court also held that special reasons for inflicting death penalty have to be specified in the decision and the execution of the death sentence has to be in accordance with the procedure specified in the Criminal Procedure Code. Then how about delay in the execution of death sentence? In T. Vattishwaran versus State of Tamil Nadu, another important principle was laid down by the Supreme Court in relation to death sentence, according to which prolonged delay, that is, delay exceeding 2 years in the execution of death sentence, is dehumanizing and hence unfair, unjust, and unreasonable, offending Article 21, and in such cases, death sentence has to be commuted to that of imprisonment for life. However, in Triveni Bain versus State of Gujarat, overruling Vattishwaran, the Supreme Court held that no absolute or unqualified rule can be laid down that in every case in which there is a long delay in the execution of a death sentence, the sentence must be substituted by the sentence of life imprisonment. The court, after considering the delay factor along with other factors, but without re-examining the final decision, may in appropriate cases commute the death sentence to life imprisonment. The Supreme Court in Shatrughan Chauhan versus Union of India held that when there is inordinate delay in deciding the mercy petitions from death row convicts under Articles 72 and 161 of the Constitution, it violates Article 21 of the Constitution. The Supreme Court also held that no time limit can be fixed for the governor or the president. The executive has to expedite the matter at every stage, which included calling for the records, orders, and documents filed in the court, preparation of the note for approval of the minister concerned, and the ultimate decision of the constitutional authorities. If there is undue, unexplained, and inordinate delay in execution due to pendency of mercy petitions, or if the executive and the constitutional authorities fail to take note of or consider the relevant aspects, the Supreme Court under Article 32 is empowered to hear grievances of the convict and commute the death sentence to life imprisonment on this ground alone. The court also framed certain guidelines so as to safeguard the interests of the death row convicts in view of the inconsistencies in implementing the already existing laws. When a question arose whether right to life includes right to die, though in the beginning the Supreme Court in P. Rathinam versus Union of India gave an overexpansive interpretation to Article 21 and held that right to life includes right to die, 2 years later, in Gyan Kaur versus State of Punjab, the court declared that the right to life guaranteed under Article 21 can by no stretch of imagination be read to include extinction of life within its purview. The court held that the right to die, if any, is naturally inconsistent with the right to life as it dealt with life. An attempt to nullify the effect of penal provision for attempt to commit suicide, that is, Section 309 IPC, was taken by the Government of India in an indirect way by enacting the Mental Health Care Act, which came into force on 7/4/2017. Section 115 of the Act decriminalized attempt to commit suicide by creating a legal presumption of existence of severe stress in every case of attempt to suicide unless proved otherwise. Regarding euthanasia in Aruna Ramachandra Shanbag versus Union of India, the Supreme Court reiterated that the right to die is not included in right to life, and hence active euthanasia and assisted suicide are illegal. However, the court held that passive euthanasia can be permitted and laid down the procedure that has to be followed for withdrawing life support to a patient in permanent vegetative state, which would be enforced till the Parliament makes a law on the subject. In Lata Singh versus State of UP, condemning the practice of honor killings, the Supreme Court directed the administration and police authorities throughout the country to see to it that if any boy or girl who is a major undergoes intercaste or interreligious marriage, the couple is not harassed or threatened with violence, and anyone so harassing or giving threats are proceeded against as per the provisions of law. Another area where the decision in Maneka Gandhi's case had a beneficial impact is the criminal justice administration. Article 21 became an effective tool in the hands of Supreme Court to deal with the excesses and inadequacies in the administration of criminal justice. The various issues that have been touched upon by the Supreme Court in exercise of its power of judicial review include arrest and investigation, custodial violence, bail, legal aid, and certain other aspects of fair trial. We all know that police is the principal investigating agency for investigating offences, and the police officer who is entrusted with the responsibility of investigation is the kingpin in criminal justice system. Wide powers, including the power of arrest, search, and seizure, are conferred on him for effective investigation. These powers are subject to reasonable regulations and control under law. There have been instances where the police officers abuse the powers conferred on them and use their authority to oppress the innocent citizens who look upon them for protection. Investigation into the offence commences on the strength of the FIR, that is, the first information report. Inaction of the police to record FIR, and where FIR is recorded on court's directions, indifference to investigate the cases hinders criminal justice administration. This led the Supreme Court to issue directions and guidelines regarding the registration of FIR in Lalita Kumari versus Government of UP. In order to protect citizens from oppression and injustice at the hands of the law enforcement machinery, The court also issued directions for enforcement of fundamental rights under Article 21 and clauses 1 and 2 of Article 22. These directions were intended to check the abuse of police power and ensure transparency of action and accountability. Illegal arrests affect the esteem and reputation of an arrested person. In D.K. Basu versus State of West Bengal, the court issued prerequisites to be followed in all cases of arrest or detention till legal provisions are made in that behalf as preventive measures. These requirements have been reiterated, and subsequently the Criminal Procedure Code was amended in 2005, 2009 and 2010, incorporating the safeguards contained in the directions given by the Supreme Court. These have been incorporated in the Bharatiya Nagarik Suraksha Sanhita 2024 also. In Arnesh Kumar versus State of Bihar, the court cautioned the arresting authority that he may be exposed to proceedings under the law for violating fundamental rights inherent in Articles 21 and 22. The court also directed the magistrates that while authorizing detention, they should record their satisfaction that the arrest was made after complying with the provisions of criminal procedure, and failure to comply with the directions would render the concerned police officers liable for departmental action as well as for contempt of court, and the magistrates would be liable for departmental action by the appropriate high court. Then comes custodial violence, which is one of the worst kinds of crimes in a civilized society governed by rule of law. The Supreme Court in a number of cases expressed concern at the atrocities perpetuated by the protectors of law and order and issued directions to the authorities and awarded compensation to the victims of custodial violence, bringing it within the purview of Article 21. In People's Union for Civil Liberties and Another versus State of Maharashtra, the court also issued guidelines for proper, thorough, structured and independent investigation of police encounters causing death or grievous hurt. In Common Cause versus Union of India, the court held that the accountability of the wrongdoer and the responsibility of the state have to be fixed in such cases. Another aspect of criminal justice administration, which involves exercise of discretion by police and lower courts, is the granting of bail. When the matter pertaining to under trials lamenting in jails due to their incapacity to provide sureties due to poverty was brought to the notice of the Supreme Court in Common Cause versus Union of India, the Supreme Court issued directions for their release on personal bonds. In Akhtari B versus State of Madhya Pradesh, where the issue pertaining to under trials languishing in jail for more than 1 year in certain cases and more than 2 years in certain cases was brought to the notice of the court, it directed their release on bail or on personal bond. In Sunil K. Sinha versus State of Bihar, where appeals on conviction are not disposed within 5 years, the convicts were directed to be released on bail. Long incarceration without trial was to be a ground for grant of bail. These directions were included in CRPC by the Amendment Act of 2005. When the provision has not been applied effectively to reduce the problem of under trials languishing in jail, the Supreme Court stepped in once again in Hussain versus Union of India and issued yet another set of directions for effective implementation of the provision. Despite all these efforts of the Supreme Court, grant of bail is still seen as an unpredictable system. Again, the Supreme Court was instrumental in recognizing speedy trial and legal aid to be inferred in the spectrum of Article 21. In Hussain Yara Khatun versus Home Secretary State of Bihar, the court even went to the extent of directing the release of under trials who have been in jail for periods longer than the maximum term of imprisonment for which they could be sentenced on conviction. The Supreme Court declared that expeditious or speedy trial is an integral and essential part of the fundamental rights to life and liberty enshrined in Article 21 and held that procedure prescribed by a law for depriving a person of his liberty cannot be considered reasonable, fair, or just unless the procedure guarantees speedy trial for determining the guilt of such person. The right to speedy trial comprehends all stages: investigation, inquiry, trial, appeal, revision, and retrial. In its zeal to satisfy the mandate of Article 21, the Supreme Court in Common Cause 1 and 2 and Raj Deo Sharma 1 and 2 devised a solution for imposing a bar of limitation beyond which criminal trial should not proceed. However, in 2002, the court in P. Ramchandra Rao versus State of Karnataka partially overruled the decision and held that court cannot fix any time limit as a bar beyond which the criminal proceedings or trial cannot continue, thereby entitling the accused to be acquitted on ground of delay because this would amount to judicial legislation. The court reminded the Union of India and state governments of their constitutional obligation to strengthen judiciary by providing funds, manpower, and infrastructure. Yet another important aspect of fair trial which received Supreme Court's attention is legal aid. When an accused cannot afford a lawyer due to poverty, the trial will not be a fair and just trial, and therefore legal aid to poor is a facet of fair, just and reasonable procedure contemplated in Article 21. The Supreme Court in Hussain Yara Khatun versus State of Bihar, referring to Article 39A and the expansive interpretation given to Article 21 in Maneka Gandhi case, held that the right to free legal services is an essential aspect of reasonable, just and fair procedure guaranteed under Article 21, and this is available to an accused person who cannot afford a lawyer to defend him due to poverty or incommunicado situation. But this right would be useless unless the magistrate before whom the accused is first brought does not feel it obligatory to inform the accused of this right. The Legal Services Authority Act was enacted in 1987 but came into force in 1995 to give effect to the directive principle relating to legal aid contained in Article 39A. Despite all this, in Muhammad Ajmal Amir Kasab versus State of Maharashtra, the Supreme Court had to reiterate the duty and obligation of the magistrate to inform the accused of his right to legal aid and cautioned that failure to discharge the same would be liable to departmental proceedings. In Imtiaz Ahmad versus State of UP, holding that expeditious disposal of a criminal case is a requirement of Article 21, the Supreme Court issued directions to all the high courts against indiscriminate grant of stay of prosecution in large number of serious criminal cases. In Manu Sharma versus State, the Supreme Court held that trial by media hinders fair investigation by the investigating agency and, more importantly, prejudices the right of defense of the accused. Prison administration is another area which received the attention of the Supreme Court. In State of Andhra Pradesh versus Chella Ramakrishna, the Supreme Court held that right to life is one of the basic human rights which is guaranteed to every person by Article 21, and not even the state has the authority to violate that right. A prisoner, even if he is a convict or under trial or a detenu, does not cease to be a human being. Even when he is lodged in the jail, he continues to enjoy all his fundamental rights, including the right to life guaranteed to him under the Constitution. On being convicted of crime and deprived of their liberty in accordance with the procedure established by law, prisoners still retain the residue of constitutional rights. The court emphasized that a prisoner was a human being and hence had to be treated with basic human dignity, and that the prisoner had a right to integrity of his physical and emotional personality. Imposing solitary confinement, putting bar fetters, and chaining prisoners indiscriminately were practices which were in practice in prisons, and the Supreme Court condemned such practices and issued guidelines curtailing the discretion of the prison authorities in these matters, and thus attempted to humanize prison administration. Though a number of directions were issued by the Supreme Court in various writ petitions, Little attention is paid in this regard by the states and the union territories. The Supreme Court very recently, in inhuman conditions in 1382 prisons, reminded the Union of India and the state governments that as far back as in 1975, in D. Bhuvan Mohan Patnaik case, it held that convicts are not by reason of conviction denuded of all the fundamental rights which they otherwise possess. The court held that there were a number of decisions rendered thereafter by the court on the same subject of fundamental rights and human rights of convicts and under trial prisoners, repeated every decade over the last so many years. The court lamented that unfortunately it seemed that the views of the court over the last 50 years have continuously fallen on deaf ears, and the situation did not seem to be changing even now. And unless due importance is given to fundamental rights and human rights of the people, the right to life and the right to live with dignity under Article 21 of the Constitution will have no meaning. Award of compensation to the victims who suffered at the hands of careless and irresponsible officers of the government is another manifestation of the dynamic constitutional jurisprudence. The Supreme Court went ahead to forge new tools and devise new remedies for vindicating the most precious of the fundamental rights, that is, the right to life and personal liberty. In a precedent-setting judgment in Rudulsa versus State of Bihar, the Supreme Court awarded 35,000 rupees as compensation against the State of Bihar to the petitioner in a writ petition filed under Article 32 because he was kept in jail for 14 years after he had been acquitted by a criminal court. The court felt that it would be rendering only lip service to right to life and liberty if it does not award compensation to victims of illegal detention, custodial violence, and such other state aggression. The court held that the defense of sovereign immunity is inapplicable and alien to the concept of guarantee of fundamental rights. A review of the cases show that the court has granted compensation in cases where the petitioner has suffered personal injuries at the hands of government servants by their tortious acts, police atrocities, custodial deaths, medical negligence, and environmental pollution. In Bodhisattva Gautam versus Subhra Chakravarti, the court went on further to state that it is not necessary that the person who is the victim of violation of his or her fundamental right should personally approach the court, and the court itself can take cognizance of the matter and proceed suo motu or on a petition of any public spirited citizen. The amount so awarded as compensation can be recovered from the erring official as thought fit by the competent authority. In inhuman conditions in 1382 prisons, the Supreme Court extended the grant of compensation to the next of kin of persons who suffer an unnatural death in a prison and held that they are also victims, sometimes of a crime and sometimes of negligence and apathy or both, and there is no reason at all to exclude their next of kin from receiving compensation only because the victim of an unnatural death is a criminal. These are some of the areas of basic human rights touched upon by the Supreme Court with the help of Article 21. Some more instances of liberal interpretation of Article 21, expanding its scope and ambit to reach other aspects of human life, will be dealt with in the next presentation. Thank you.